Hello everyone, hope you all are doing fine. This is Gautam from Shailaja IS. And yet another video on your mains current affairs issue. Here we will be looking into the Foreign Contribution Regulation Act, the Amendment Bill which was introduced in the budget session of Parliament 2026. Although it has still not been passed by the Parliament as of April first week, it has been severely opposed and protested by the opposition. So, in this video, we'll first try and understand the evolution of the legislation itself. As the name itself suggests, Foreign Contribution Regulation Act, it is trying to regulate whatever is the foreign contributions that are flowing to certain organizations. We'll try and understand the historical background for that particular legislation, and we'll try and understand what are the new features that are being introduced in the Amendment Bill 2026 and the criticisms associated with these newly introduced features in the bill. Right? So first and foremost thing, if you trace back the history of this legislation, it falls back to 1976 emergency era, whereby the then government, which was headed by Indira Gandhi, felt that it was necessary to control or to restrict the funding that was going to political persons and political entities. Obviously, during emergency time period, our country had turned from a democratic nation to a more authoritarian nation. At that point of time, the government of the day was less tolerant to any contrary views or opinions, or less tolerant to the opposition itself. And most of some of these organizations or entities were being funded from your external agencies, primarily from your USA, so as to create some sort of an instability in the nation. So the government of the day felt that we need to have a legislation which is put in place, which is going to give approval with regard to flowing of funds from foreign entities to certain political persons and political entities in India. So the 1976 Act primarily banned the foreign contribution to political persons, political parties, or political entities. It also prohibited or banned foreign contributions to government servants, to members of judiciary, right? So it was largely an election-focused legislation that was passed in 1976. Okay, the scope of foreign funding was largely being restricted to political activities, but over the periods of time, as and when the economy opened up in 1990s, we saw increasing inflow of foreign funds into India. Most of it were used for your economic commercial purposes, which was regulated by RBI. Obviously, the 1976 law completely banned foreign funding into political activities. So political activities is banned. Commercial activities or investment activities is being regulated by RBI. But foreign funding were also used for something called as social activities. So funds were flowing into NGOs, that is your non-governmental organizations, to carry out certain activities, maybe like spreading awareness, maybe like providing education, like providing skill training, okay, so on and so forth. Okay, we are having big organizations who are actually being funded or who are actually getting foreign funds in a considerable amount. So since this new category of foreign funding cropped up from 1990s and 2000s, it was felt that we need to have a more comprehensive Foreign Contribution Regulation Act, and therefore 2010 an updated legislation was passed, which gave a more comprehensive framework about foreign fund regulations. It provided for a full registration regime under Ministry of Home Affairs. So any NGO who wanted to get foreign funds first has to be registered with the Ministry of Home Affairs. They have to tell who are the members, who are all of the members of that NGO, what activities it is involved in, why you are getting foreign funding. All those registration and approval procedures were put in place through this 2010 Act. If you look into the core focus of the legislation, it changed from primarily restricting foreign funding to political activities to regulating foreign funding to a much more broader civil society. Right? So the election focused law that was in 1976, it transformed itself to a more comprehensive regulation whereby it regulated the foreign funding of civil society. So your domain of regulation was not only your political parties or your government employees or judiciary or the media, but also included a much larger civil society that includes your non-governmental organization, news and media industry. So 2010 legislation as clearly states that foreign funding is prohibited for people for your news and broadcasting industry, right? 2016 and 18 under our Modi regime, the regulations were further tightened, okay, whereby the compliance requirement was made much more stricter, whereby you have to submit your financial audit reports every year without fail, otherwise you are going to cancel your license. You have to disclose exactly the activities that you're undertaking. So they tried to put in much more tighter requirements with regard to the transparent functioning of the organization itself, right? 2020 was one of the most consequential amendment, whereby it made a much more tighter rules, whereby it said that, see, what was happening is that if suppose 1 crore rupees is being taken as a foreign funding to a particular NGO, most of the times, rather than spending it on intended purposes, some of the money was spent on persons, travels and other things under the heading of administrative cost. So if you're getting 1 crore to distribute books to the rural children, if you look into the accounts of it, they were saying that 50 lakhs was spent on administrative cost, like paying rent to the NGO building, paying salaries to the NGO staff, travel and accommodation expenses. So that itself, some of the NGOs were misusing it and at 50 lakh rupees. The remaining only small amount, they were giving it for the actual purposes. So your NGOs are turned into a tax evasion organizations. So in order to deal with these kinds of activities, the 2020 amendment clearly stated that whatever foreign funding you are getting, you can at the maximum use 20% of that funding for your administrative cost. The remaining 80% should be used for the intended purposes, right? Because it has to get approval from the Union Home Ministry. Okay, so suppose it says that there is an organization, like for example, Greenpeace India is working for your environmental sustainability in India. Amnesty International is working towards human rights violation. Obviously, these two are now not functioning because of all these strict guidelines. These organizations were getting money from your foreign agencies. Okay, it might be charitable trusts, it might be US government agencies, and some of these organizations were spending too much on the administrative cost, and they were not spending it for the intended purpose, right? So this amendment specifically brought in this restriction. Another important restriction which the 2020 amendment brought in was that it said that all the foreign contributions should flow through a dedicated account that NGO has to open in the SBI branch of Delhi. So there is one bank, one account for an NGO, and all the foreign funding should flow through that. So that was one of the amendment made, because it leads to better oversight by the government, because SBI is ultimately owned by the government. So it leads to a better oversight. Third important aspect is that it restricted the bigger organization from passing funds to a smaller NGOs. That is what was actually happening at the ground level. See, if there is a big NGO, they will not necessarily employ the ground staff in order to carry out their NGO activities. They generally fund much more smaller NGOs. So that passing of funds from a bigger organization to smaller NGOs was restricted under this 2020 amendment. So all of this is happening under the pretext that the foreign funding is being misused by NGOs to destabilize India. That was the underlying argument that was given by the government in order to bring in such restrictive regulations. Right? 2026, the new amendment bill has gone one step further, whereby it has made registrations much more stricter from a procedural point of view. Okay, if the registration ceases, it can be when a renewal application is not made, or if the application is made but it is unable to get the renewal, or if the renewal itself is denied, or it is cancelled or surrendered. In all these cases, it is considered that the NGO has stopped functioning and it is no more eligible to get foreign funds. So if I am an NGO who is working, I am more focused on getting bureaucratic approvals because of these tight regulations. Right? I need to get renewal and I need to get it within time period. And I need to submit all the audit reports, compliance reports, etc. Only then my renewal application will be approved. Only then I will be eligible for foreign funding. So government is trying to have a more tighter control on the working of NGOs. Second thing is the deemed authority. Now what happens, suppose I am an NGO. I have certain assets because I have I'm having maybe I have purchased a land or purchased a building, or I might have purchased few computers with the help of this foreign funds. Now my registration certificate is cancelled or it is not renewed. So what will happen to these assets? It will be provisionally vested with a deemed authority. Right? So whatever was the building I was having will be provisionally vested with the deemed authority. So a specific authority is going to be established who is going to deal with these cases. Now why do you say this? Because the last 10 years, if you look at the licenses that has been awarded for the NGOs, we have seen a drastic fall in number. In 2014, around 35 to 40,000 NGOs were functioning in India and they were given the licenses to operate in India. But because of the stringent requirements in 2016 amendment, 2018 amendment, 2020 amendment, nearly 20,000 NGOs licenses were revoked. So currently, as of March 2026, we are having around 13 to 15,000 NGOs who are currently functioning in India, right? And they are further tightening the screws of these NGOs, okay, by saying that you will be your license will be revoked if you don't get approval within the timeline, if you don't submit the necessary documents, and whenever it is suspended, when the license is suspended or revoked, whatever are the assets, that will be provisionally flowing into the deemed authority. Okay, so and if it further fails to provide the documents, it will be permanently vested in the deemed authority. Okay, so for example, there is an NGO X, and it has been functioning for the last 10 years. It was able to purchase one land or building for its own office activities, or it was purchasing computers, or it was purchasing books, or whatever are the assets that it was having. It might be even having certain FD, fixed deposits in the bank. And if the registration is not being approved, or if the registration is revoked, all these assets will be flowing to a deemed authority. So the land ownership, the computers ownership, all the FD ownership will be flowing to the deemed authority. And furthermore, if the organization is unable to submit the necessary compliance reports, if it is not able to get renewal within the opportunity given, then it will be permanently vested with the deemed authority. In a sense, the deemed authority will make use of all these assets for its own purposes or for the public benefit. For its own purposes means what? For paying rent, for paying salaries, for people who are involved in this deemed authority, right? Next, they have expanded the prohibition of foreign funding. Earlier, your media and news broadcaster was under the ambit of FCRA, which prohibited foreign funding to this particular state and media industry. Here, they are also involving any person clause, which means that any person who is engaged in news or current affairs activities are prohibited from getting foreign funding. So they are widening the ambit. Earlier, only publisher, editor, cartoonist, or the owner was under the ambit of FCRA. Now, even the ground level reporter can be brought under FCRA. So they are trying to plug all the loopholes that were present in the earlier legislations, and they are going to further tighten the funding or the flow of your foreign funding. Right? Some of the other requirements was, it has brought down the punishment time period for violation of FCRA from 5 years to 1 year. So that one leniency has been put in place. Second thing, a prior recommendation of government is very necessary before any investigation is started against an NGO. So this can be misused by the government authorities. Okay, so for example, there is NGO A and NGO B. This is in favor of government. NGO A is in favor of government. NGO B is not in favor of government. It is trying to point out to its deficiencies. It is being more critical about its policies and actions. If any investigation needs to be opened against A or B, first it has to get approval by the government. So government, what it does in actual reality, it will give permission to start investigation against B, because B has always been critical about the government policies. Okay, it has always pointed out to its weaknesses and shortcomings, and it has always asked tough questions. Whereas A, which has been more or less towing the line of government, the government may not even give the permission to start an investigation into the activities of A. So this one provision has been started where prior approval of government is needed, but it can be misused to favor certain NGOs who are aligning with the ideology of the functioning government. Obviously, another thing that they have made is 90 days time period has been given whereby they can appeal to the judgment of any judgment given by deemed authority to a district judge within 90 days. Okay. For example, deemed authority says that your renewal application is not correct. Your documents are not correct. I'm not going to renew your application. So that is the judgment given. That judgment can be appealed to district magistrate or district judge within 90-day time period. So these are all some of the provisions that are given in this new amendment bill. It is still not passed. Okay, so changes might be introduced, but I'm just quickly recapping of the evolution of this FCRA. So it started with election-focused law, brought in the entire civil society under its ambit. 2016, 18, and 20 made compliance much more restrictive and made foreign funding a much more tougher task. 2026, it is trying to establish a deemed authority and vesting it with the ownership of the assets itself. Right? So some of the concerns here is, see, the asset seizure part of it is very disproportionate. See, you might not be able to submit your compliance report within the prescribed timeline due to some small challenges. For that, seizing the entire asset, how fair is it? Okay, so that is one criticism that is being made. Second thing, whatever is the deemed authority that you're establishing, what sort of oversight mechanism are you putting in place so that it is not being misused? Okay, so except for that appeal period of 90 days to a district judge, there is no other oversight mechanism. Is it going to submit the report to the parliament? Is the, you can say, a selection criteria of this committee going to be approved by a committee having both opposition as well as the ruling party members? So what safeguard mechanisms you are trying to put in place in order to regulate or monitor this deemed authority? That is another question that is being raised. Finally, there is a very curious case of mixed fund assets. In the sense, for example, a land or a domestic, whatever I showed you, the building, which is now being seized by the deemed authority due to failure of registration, that building might have been purchased both from the domestic sources as well as foreign funding. So it is being used, but it is being seized because foreign funding was involved. So there is concern that is raised about the assets which are constructed partly by foreign funding. If it is funded entirely by foreign funds, okay, there is a fair argument that is being made. Since it is entirely funded by foreign funding, we can seize it. But if one of the assets is being created both by domestic funds and foreign funds, how fair it is to seize such kind of assets, right? Another, as I already told you, the investigation gate where you need to get the approval from the government, that can be misused against NGOs which might be favoring or not favoring them. Minority institutions are going to be disproportionately impacted because of restrictions that are imposed on foreign funding flow, right? And you're covering under the media industry any person who is involved in your news and broadcasting activities. So that is again creating a chilling effect. Chilling effect means where people are going to undertake self-censure activities, or they're finding it too restrictive to operate, right? So these are all some of the criticisms against the features of the 2026 Amendment Bill. Hope you have got a fair idea about what the government is trying to do by bringing in such legislations. On one side, it is being argued minimum government, maximum governance. That was the motto that was given by the government of the day, right? But if you look at some of the legislations, your FCRA Amendment Act, or in my earlier video, I had talked about your anti-conversion bill. If you look at these two legislations, somewhere the very motto of minimum governance, maximum government is being undermined, right? Nevertheless, we are going to view all these issues from a bureaucratic administrative angle and not from a political activist dimension. Okay, we are not going to be another the Hindu editor, right? We are going to be bureaucrats, so you need to understand the underlying principles of it. So I hope you got a fair bit of an idea on this particular topic. Let's look into one of the questions. Regulation of foreign funding is a legitimate state interest, that is correct. But it must be balanced against your constitutional rights and international obligations. Examine the statement in the context of FCRA regime. So you give me the arguments in favor of the regulations and you give me the criticisms of the regulations, right? So that is what the question is looking for. If you're able to attempt it, please send it to me on my Telegram or WhatsApp on this number, or you can email to my email ID. Looking forward for your answers. If you have any doubt, if you want any feedback, you are free to contact me on this number. All the very best.